On March 12, the widow of Cradle Fund CEO Nazrin Hassan and two underage boys pleaded not guilty in the Shah Alam High Court to a charge of murdering him in June last year. They were charged under Section 302 of the Penal Code, read together with Section 34, which provides for the mandatory death sentence upon conviction. The boys I mentioned earlier are 13 and 16 years old respectively, which got us thinking, what happens when a child, in this case children, are convicted of such grave crime? We don't hang children, do we? According to the Child Act 2001, a child is defined as a person under the age of 18 years old, and in relation to criminal proceedings means a person who has attained the age of criminal responsibility as prescribed in Section 82 of the Penal Code. But what's that? According to Section 82, nothing is an offence which is done by a child under 10 years of age.
Any person who is below 18 years of age is regarded as a child by the criminal law, and this is clear from the Child Act 2001. The Child Act is very important because that is an act that was brought in response to our country's obligations under the Child Rights Convention.
Child's Act was enacted to protect children. So in Child Act, they have certain procedures to be followed when a children is charged in court or children is brought to court.
The charge may sound familiar. You've probably heard several adults being tried and convicted of such crimes, but when it involves a minor, the process is very different, and the Child Act makes sure of this.
If a child is charged in court, they will be charged in court, the court known as Court for Children. So in Court of Children, of course, there will be certain prohibition in terms of publication of names of children and all that.
And of course, the child is treated very much differently from an adult, both in terms of the arrest process, the bailing process, the places where they are kept, places of detention where they are kept, and also in terms of sentences that will be available to be meted or to be passed on them, assuming that they are found guilty. So it's a completely different scheme under the criminal justice system for children as opposed to adults, which is as it should be.
Let's say a child is convicted of a crime, they will not be sent to an adult prison.
Now, like my other clients, like the Tafiz clients for example, pending the conclusion of a trial, then of course they have a new rehabilitation center in Shah Alam. So that is exclusively for juvenile offenders awaiting for trials.
Okay.
Yes. But if they are convicted and sentenced, they will be sent to normal prison, like in Kajang, for example.
So it will be normal prison.
Yeah, but of course they will different. They will be separated from adult offenders. So that's what they say.
That's what they say.
That's what they say.
So once they turn 18, they would be basically moved with the rest of
Yes. Okay.
Okay.
But the sentence is maintained. That is at the pleasure of young Betul.
But what if a grave crime is committed by a child, for example murder? According to Section 97 of the Child Act, a sentence of death shall not be pronounced or recorded against the person convicted of an offence if it appears to the court that at the time the offence was committed, he was a child. In lieu of a sentence of death, the court shall order a person convicted of an offence to be detained at the pleasure of the Agong or state ruler.
Now, if a child is found guilty of an offence of murder, for example, where the only punishment available under the law for the judge to mete out is death. There is no other, it's mandatory death sentence. But if the person found guilty is a child, the sentence of death cannot be pronounced. It cannot be passed. So instead, what the judge can do is sentence the child to detention at the pleasure of the Yang di-Pertuan Agong, or if the offence is committed in a state, the pleasure of the Sultan of the respective state.
There may be some people who feel that these children have it easy compared to adults who have committed a similar crime. But do they really have it easy?
Firstly, the authorities must remember that the child who has been charged is innocent until proven guilty. Secondly, you're dealing with children. So, I mean, both society and the government must not look at them as criminals just because they're charged, but as children who have been, you know, who are having this encounter with the criminal justice system. So they must prioritize the welfare of these children. But because supposing that the child is eventually acquitted, can you imagine the trauma that the child is going to go through because of this process of being arrested and remanded and charged and put through trial? Suppose he's innocent. So we have to balance between the needs of society to obtain justice for a crime with the impact that is going to be there on the child. In fact, if you ask me, can a child that has gone through something like that ever recover from the trauma? Are there studies? What happens to them after that? Nobody pays attention to that, unfortunately.
This is just theory. Of course, they say the child is protected,
Right.
this, that, and the other. But in actuality, we don't know really, because you cannot really access it. Only Suhakam and all that can ensure that these protections were actually afforded.
So there you have it. Malaysia does not hang children for grave crimes, but if you're an adult, the death penalty could still be imposed on you. It may not be a mandatory death penalty in the future, but looks like the courts will be able to impose a death penalty at its own discretion for 11 criminal offences. For more videos like this, let us know in the comments section what other topics you'd like us to cover. I'm Prasadh. Thanks for watching.